Should I be getting rid of my employer's confidential information from my personal devices if I sign an employment-related settlement agreement? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Morally, the answer to this question is yes. Legally, the answer is it depends on what you have agreed in writing, bearing in mind that there might be a confidentiality clause in the settlement agreement itself and a clause dealing with what confidential information means. Now, this is usually one of those must-have clauses in a settlement agreement for an employer because it wants to protect its business, but it has to do that in a way that doesn't prevent you from being employed somewhere else, as long as that doesn't affect its ability to run its business. Now, also typically this can be extended not to just your personal devices and storage systems, but also those of third parties who you are in contact with and who likely have that information on those devices and storage systems. So say, for example, that your partner has a laptop or a mobile phone that has information relating to the employer on it. You may then have to remove that information from those devices and storage systems as well, not just your own devices and storage systems. Now, once again, there are certain things that are excluded from this. So your contract of employment, your P45, your P60s, the settlement agreement, your pay slips. They're all yours. They're there for you to have in the future, so you don't need to get rid of them. But anything else, particularly things relating to your employer and the way that it does business, may have to go. So I hope that's answered the question. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.